Good afternoon. We have a very interesting session, Justice of the Future, and I have on the screen a number of guests, both from the Republic of Moldova and from abroad. Some of them will join us online. And I would like to start by giving the floor to Aurelia Palamarchuk, who will present some data. She is the legal advisor of the Legal Resources Center from Moldova. So please, the floor is yours. I will make a brief presentation of this topic, Justice of the Future. I'll present the information system of the court system of Moldova. It consists of a number of elements, case management information system, recording system, and the national courts portal. The IT solutions in justice and how they are used. We know that e-summoning and audio recording are being used. Video conferencing is used in certain criminal and contravention cases, for example, to hear persons who are in detention, whereas video conference is used for witnesses and translators after the law was amended in 2023 and 2024. Case file is pilot tested now, and now we are working on the concept of the criminal case, and the system is managed by the Minister of Interior and is used for criminal investigation. And now I will present the automated information system Justat, which is a new system. It was launched in 2023. It is initiated. It's intended to implement countrywide the Stat concept. Regarding Justat system, it is used to analyze statistical data. It has 4 analysis components. The first tables shows the efficiency of case review by courts, and here we have the rate of cases solved, duration of cases, pending cases. The second table shows the appeals against court judgments, the rate of appeals and the rate of files that were appealed. Table number 3 shows the ratio between human and financial resources to the outcomes. Here we have data on the caseload per judge, caseload per employee, complexity level of cases, as well as the costs of a case. I have here a print screen of this table showing the caseload per judge, and we can see in what courts we have the highest caseloads per judge. Here we see the number of cases pending, both civil, contravention, and administrative for all courts. I would like to say that this system generates data since 2021 to 2023 and the first quarter of 2024. And now I would like to speak about artificial intelligence, how it can be used, and if Moldova is ready to start using it. Oxford Insights published an annual report which shows the government's preparedness level for AI. The Republic of Moldova ranks 90th out of 193 states that were evaluated at the global level. The government's preparedness index is based on 3 indicators. The government, which shows the strategic vision of how the government is developing and governing artificial intelligence. Technological sector, which assesses the availability and quality of the IT sector. And the third indicator is data and infrastructure, meaning the availability of the needed data in each specific country. You can see the scores for the Republic of Moldova. The maximum number of points is 100, and we can see the scores accumulated by the Republic of Moldova. So the government 48.6, IT sector 28.21, and availability of data 58. The same report ranks the Republic of Moldova 18th in the Eastern Europe, followed by Bosnia and Herzegovina and Belarus. This slide shows that we still have a lot of efforts to implement in this regard. And by signing the Framework Convention of the Council of Europe on artificial intelligence that was signed this year on September the 5th, we hope that this will result in better indicators next year. We were curious to find out how a digitalized justice could look like in the future. We asked this question ChatGPT, and these are the answers generated by it. This would be digital platforms, electronic case management, and online portals to ensure access to the judiciary, virtual meetings and hearings using video conferences and remote participation, as well as communication platforms for parties to the process, to the proceedings. Another answer was use of artificial intelligence and automation. That can be used to review the legal framework, digital access for citizens, online portals to submit complaints or applications. And now I encourage you to think about digitalized justice, what it might mean for the Republic of Moldova, and I wish you to have a productive discussion. Thank you very much, Mrs. Palamarchuk. Your presentation and the data presented are very interesting. Now, we have a video material, Vox Populi, which will show us what is the people's opinion about using artificial intelligence in the judiciary and this concept of justice of.
Așa cum e promis în campaniile electorale, nu așa cum se întâmplă după campaniile electorale.
Reformat.
Cum credeți și cum vă imaginați viitorul justiției în Republica Moldova?
Viitorul e o justiție corectă, bineînțeles, fără ca cineva din altă parte să se implice în procesul justiției. Se utilizau tehnologii de înregistrare, transcriere, păstrare a tuturor ședințelor, ședințele online și așa mai departe.
Audierea martorilor în ședința de judecată a părților vătămate, inculpaților, este posibil deja să nu fie tapate toate declarațiile de către grefiere, dar sunt deja tehnologii care automat mot se indică în proces verbal, în declarație, în calculator. Și atunci e ușor de tapat, adică nu pierdem timp în ce sens.
Atunci când părțile sunt de acord să examineze inclusiv prin aplicații digitale, web, Zoom sau o aplicație integrată în cadrul PIC, atunci e binevenit, deoarece aceiași timp de transport. Da? Dacă vorbim în Chișinău, un avocat ca să prezinte în cadrul Curții de Apel Chișinău din sector, urmează să piardă mai mult de o oră de timp pentru deplasare, să caute un loc de parcare, să-l ocupe locul cel de parcare, adică ulterior să aștepte câte jumătate de oră, o oră, în cel mai bun caz, la Curtea de Apel, pentru a intra în ședință. Deci tot timpul acesta avocatul practic nu lucrează, deci nu poate să asigure o asistență juridică pentru alte dosare care poate au o importanță mai mare sau cel puțin sunt mai de urgență.
Ну, есть дела, где ведутся, не знаю, годами, есть где короткие, надо за короткий срок быстро все решить, почему бы те дела отдельно быстренько не сделал и не откладывать их на потом. И быстро все решается.
Cred că nu e pentru Moldova.
De ce?
Atât, dacă populația și cultură joasă, general, și cultură în domeniul justiției tot e jos.
Nu pot să explic, dar nu cred că poate un robot sau ceva, un intelect artificial, cum spune, să poată să ne judece pe noi sau să ne spui că am făcut noi bine sau am făcut noi rău sau ceva de genul.
N-aș opta pentru așa chestiune, ori mai există intima convingere, mai există aspectul de individualizare față de persoană, deci iarăși câteodată judecătorul vede doar persoana fizic și își dă seama, el este infractor sau nu este infractor, deci aspectele psihologice și psihosomatice a persoanei sunt foarte importante, eu cred, în unele aspecte. Deci sunt proceduri simplificate care și așa se examinează fără părți, în procedură scrisă, deci eu cred că unde și-a găsit rostul examinarea fără părți, deja este stabilită și inteligența artificială în acest sens n-ar trebui să fie implicat cel puțin în sistemul justiției.
Justiția trebuie să fie efectuată prin și factor uman, trebuie să persiste. Dacă noi permitem inteligenței artificiale să ne decidă soarta oamenilor, noi să ne trezăm într-o zi toate cauzele să examineze și în genere a decide soarta omului, care nu are nici simțuri în acest sens.
I also watched an interesting material about the opinion of people and professionals about using AI in various areas, including in the judiciary. But let's see the opinion of our guests. We'll start with Sorin Popescu, Director of the Agency for the Administration of Courts, Minister of Justice. We have Daniel Schmidt with us online, Secretary of the Working Group for Digital Justice and Artificial Intelligence of Council of Europe. Hello. He has not yet connected. Let's continue. Tatiana Chaglik, member of the Superior Council of Magistracy. Nathan Brooks, international lawyer for hacking, informating, and intellectual property of the U.S. Department of Justice. Hello, Nathan. Can you hear us? Okay, thank you. We also have Andrei Ozhoga, judge at the Chisinau Court. Hello and welcome. Last but not least, we have with us, again online, Miriam Stankovic, Chief Specialist in Digital Policies of the Center for Digital Acceleration. Can you hear us, Miriam?
Yes, I can hear you. Can you hear me?
Yes. Hello, and thank you for joining us today. Așadar, vom începe cu
So let's start with the first speaker, Mr. Sorin Popescu. In your opinion, how a digital justice should look like, what plans have been made in this regard? Just to set out the rules, each speaker will have about 10 minutes to make the presentation, and then we will have the Q&A session. We will receive questions both from people in the room and for those watching us online. Esteemed audience, hello. I would like to congratulate the team of the Legal Resources Center from Moldova for organizing this event. Thank you for the invitation. That's a good opportunity to speak about justice from the digitalization perspective. If you remember, maybe last year during the same forum, we were speaking about the reorganization of the judiciary and the court's map. We were discussing how complex this process is. And I am glad that this process has ended. We had a lot of debates on the matter. Some of them were hot debates, but they are very needed in order to identify the best solution. So, the Minister of Justice would like to reset the competencies pool by digitalizing the processes. And we set out to achieve our goals in a short period of time. Let's take them one by one. I would say that the future is already in the present. We have progressed quite a lot in terms of digitalization. Of course, not everything is ideal in terms of digitalization. I have studied the experience of other countries. Some countries do it differently. A good example would be Estonia, which, though a small country, it has become a promoter of digital services worldwide. This year, our partners from the World Bank presented the results of a screening of business processes in the whole judiciary sector. The National Administration of Penitentiaries, National Probation Inspectorate, and other institutions subordinated to the Minister of Justice, plus Prosecution Office, and of course courts. The reality made us ponder. The approach is fragmented. The information systems are at different maturity stages. Some of them are very state-of-the-art, and others are almost not used at all. So a lot of effort is still needed to ensure 100% digitalization. The same conclusion was formulated by Estonian experts who made a study here, as well as other studies performed by various NGOs. Everyone has highlighted that we cannot continue in the same pace if we want to have progress. So the Minister of Justice has to take the leadership role, to have a comprehensive approach, to have the possibility to apply for funds and receive it. The system has to be digitalized in a uniform manner. The U.S. agency, the relevant U.S. agency, is responsible for judiciary. I will not repeat it, but if we are to try to imagine what would have happened unless we had these tools implemented, I believe that we have to travel back 5 or even 10 years. And all of the achievements were done thanks to the continuous support by development partners. Now these instruments ensure access to justice, transparency, it minimizes corruption elements, and last but not least, it helps save time and resources that are so in demand now. Until 2010, it was very difficult to collect statistical data, because during that period, all of the statistical work was done manually. Now everything is automated, including thanks to the implementation of Justat information system. Now, making a single click, we can have access to any judiciary material issued by any court. The traceability of our action is also very important, and it provides security to the court user who knows that this ensures compliance with the law, better compliance with the law. But of course, like any other system, this information system is a living system that has to be continuously monitored and improved. And we also made the necessary legal amendments. The Digital Development Strategy 2030 stipulates briefly the need to integrate the corruption fighting strategy in the digital plans. On the other hand, the sector policies define extending the case file, proper equipment of institutions with software and hardware, and all of those actions have to be implemented by the end of 2025. And the biggest challenge is to make sure that all of the information systems are interconnected, because they were developed separately in different period of times by different developers. And now a big challenge for us is to find a way to make sure that they are interconnected. In 2022, the agency picked the integrated case management program. Now some of the institutions are already connected, whereas others are still to be connected. We have a number of applications. Regarding results, I would like to say that this year the CSM expanded the use of e-case file system in all national courts. Last year it was implemented in 7 courts. This year it is implemented in all 15 courts. We are now in the process of signing an agreement of cooperation with the Chisinau Bar, and there we will set out some clear rules for pilot testing of this solution, and after that it will be rolled out to cover all of the institutions and professionals. Our goal is that when we implement it, to have a higher percentage of applications and other documents submitted online. Of course, this cannot be done by the Ministry of Justice only. We need to have the contribution and input of all stakeholders. In 2023-2024, the legal framework for extended use of video conference was approved both for civil and criminal cases. Moreover, now the Criminal Procedure Code allows hearing witnesses at the criminal investigation stage remotely. So we hope that this will streamline the process and will help us review much quicker the cases. The Minister of Justice, with the support of partners, developed the platform of legal professions. This database is still to be populated with data. These are mediators, bailiffs, experts, notaries, and interpreters. All of them will have a personal cabinet, but this huge database has to be populated by somebody. And again, the ministry does not have this resource, and we need the support of self-management bodies for various professions. Regarding apostille, if you remember, in the past, the people had to queue up in long lines. Now they can receive it in one click only. Another process is the preparation for the bilateral screening that will take place in October. And the experts from the European Commission would like to make sure that we have a calendar, a clear vision, and the needed resources. And we know what we want to do and how to do it. So the Minister of Justice is working now on capacity building. A new agency will be set up. This will be called Agency for Justice Digitalization. And we believe that by the end of this year, we will have a functional agency. It will have the mission to ensure quality of public services in the judiciary, monitoring and streamlining the judiciary by applying and maintaining IT technologies and management of court work. So as you can see, the court management will be the mandate of this agency. So this agency will have 63 employees. The draft is public. You can review it. The agency will be in charge of digitalization and administration. We would like to have a council that will coordinate digitalization, which will set the priority activity direction and will monitor how they are implemented. Now we are working on the concept paper of a strategic document, digitalization of the judiciary for 2025-2028. So we have already started to receive legal opinions. Some of them are not very encouraging. For example, some people say that you have to stay within the existing resources and use the existing budget to do the digitalization. And I have to tell you that this is not possible. Because we have to ensure the accounting, HR, and other functions that have to be covered by the Minister of Justice. So currently, the number of employees is much lower than needed for proper digitalization. And we have to admit that digitalization needs investments, needs high-quality professionals, and so on. We need to ensure consistent support by development partners. And it's very beneficial that many of them are supporting the systems, but I believe this is not a sustainable approach. We have to make sure that the systems are supported by the government authorities. Currently, the subordinated institutions manage more than 20 information systems. It's important to understand that the judicial reform and the transposition of the EU directives and regulations will bring additional work volume for everyone. And of course, speaking about artificial intelligence, I will address them at the Q&A session.
Thank you very much for your speech, your presentation. I understand that you have a lot of challenges in terms of human resources, financial resources, and it would be good to find solutions as soon as possible for these challenges. Thank you very much. Now over to Daniel Schmidt, Secretary of the Working Group of Cyber Justice and AI from CEPEJ, Council of Europe. Hello?
Hear us?
Yes, hello. Good afternoon. Can you hear and see me?
Good afternoon, and thank you very much for joining us today. And I hope that you will guide us through this digital justice and also this issue of artificial intelligence used in the judiciary system. So please, Mr. Schmidt, the floor is yours.
Thank you very much. I hope you can hear and see me. Is that the case? Yeah. And thanks again. It's a great pleasure being with you this afternoon, at least virtually. It's also very interesting for me to learn more about what is happening in Moldova because I'm not an expert on Moldova, so it's very enriching for me. The future of justice, I don't have a crystal ball, but I can share with you what we can see already now, because the CEPEJ is following these developments systematically, and that might inspire us also to see what questions we should ask for shaping the future of justice, because I think it's important to underline that this is a process that needs to be steered and it's not coming by itself. So I would like to share here, this slideshow. Can you see the presentation saying second panel, the future of justice?
Yes, we can see it.
Now changing, digital transformation of justice.
Just one moment, my colleagues will put it on the screen.
Okay.
Just a moment.
Okay.
Yes, we can see it right now. Thank you.
Very good. I'll move on. So probably at first I would like to have some words about the CPESH and also talk about some concrete tools we provide in this regard. And I said I would like to talk about some findings we see in the digital transformation of justice. So I spoiled it already. I think the future is digital, at least from my point of view. And also to present some positions of the CPESH on the digitalization and also artificial intelligence in justice in this regard. Just to recall, I noticed that apparently you know very well what the CPESH is, the European Commission for the Efficiency of Justice. Just to recall, we were founded more than 20 years ago under the high influx of cases to the European Court of Human Rights, in particular addressing Article 6, right to a fair trial, and there addressing the length of proceedings. So our task is not only to see how proceedings can be expedited, but also how this is done in conformity with the convention. So it's not only about doing it faster, but also doing it right in that sense. And the big question is, of course, if digitalization and AI can be the right tool, the rocket, so to say, to expedite this. Just a short snapshot also of the activities we do. We talked about statistics already in the introduction. So we provide objective data for comparative view in this regard. More on the issue of AI, we provide a resource center on cyber justice and AI, where we look at these tools that are emerging in a more qualitative way, that you can really discuss concrete tools, that we know where we are in this regard. And we provide also concrete guidelines addressing some of the issues that were already mentioned, like video conferencing in judicial proceedings, or also on online alternative dispute resolution. And I think just to close this quickly, already in 2018, we issued a charter guiding on how to use AI systems in the judicial system, because the judiciary is a very specific domain in this regard. Now, coming to it, the future, as was also said by my previous speaker already, the future is already now. So we're talking not about a distant future. When it comes to digitalization, it's happening already. I show you on the slide the ICT index we provide. You see the darker countries on the map, where this is a bit more advanced than in others. And Moldova is in the middle field. On the other part of the screen, you can see it a bit more in detail, the ICT Development Index. Overall, the dot that you see, this is the position of Moldova, and the yellow bar is the European median for more than 46 countries. So in overall, we see a slight position above the median, so you don't need to be very, very modest in this regard. When we look at the overall deployment rate at different branches of law, we see a bit under the median in the civil area, more or less in the median with the criminal, and a bit below also in the administrative field. So then we can divide it further in different fields, like communication with courts, where it's a bit lower, a bit higher in the courts and case management, and also higher in decision support tools, what are there. So this is an index, so what is inside there? For example, in the communication with courts, is there a database of court decisions, record of criminal convictions, writing assistance tools, voice recording, and so forth. Courts and case management, is there an electronic case management system that was mentioned already? But also budgetary and financial management and assessment systems. And the communication is more the e-filing systems, are summons transmitted electronically, is there video conferencing applied? But this should just give us an idea where we are in the future that is happening already now. I can also say that is a snapshot of actually 4 years ago already. And the new CPESH evaluation is coming out at the end of the year. But I can also say, I think that's no secret, the position of Moldova didn't change much in the overall comparison in this regard. But what about AI that was also mentioned? And we think that is definitely the future of justice also there. In this regard, as mentioned, we monitor also the situation there. So you see on the map, you see also there the darker countries, the darker blue, where we see more AI systems that are applied. And you see in Moldova, we are not aware of anything. So I'm really looking forward also to this discussion. So for me also to learn something what is happening in Moldova. And there we see, in this picture that we see, we identified more than or around 120 applications at the moment that we group in different areas. So for example, in document search, review and large-scale discovery, search engines for case law, for example, online dispute resolution, more integrated systems for resolving disputes online, prediction of litigation outcomes, the classic how to predict the outcome of a case. To mention there on the screen what you see also the colorful spheres. The bigger they are, the more tools we have. So when we talk about, for example, about the prediction of litigation outcomes, we don't see many tools that are applied there by the courts we looked at. But we see many tools in the area of decision support, but that is also a very wide area where there are tools that are summarizing texts or extracting specific information in applications to the courts or calculating scales for sentencing and so on. So this is all happening already right now. The same as anonymization or pseudonymization of court decisions before their electronic publication, which is very tedious work. So there are many applications out there. E-filing systems as such, you see, not all countries yet have e-filing systems, but they are basically the prerequisite for further advance also with digital processing. And we see many tools in the area of workflow automation or organization, transcription and translation tools, and information services for the interaction with potential court users or the citizens, such as chatbots. We can also look then if this is more available for judges or lawyers, or if these are purely academic exercises. Also there is work in progress. It's not necessarily a representative, so there are probably more tools out there, but progressively we're working on this to identify these tools, and then we have the targeted discussion on them. But let me talk about a little bit three areas which are always in the focus of interest: prediction, autonomous decision making. Is there a robo-judge? I would like to cite a 2019 article which was claiming that Estonia is building a robo-judge to help clear legal backlog. So Estonia had to deny this at a later stage. So we don't see the robo-judge there, and we don't think that is the future. So what we see actually are more support tools. To give you some examples, like an anonymization tool in Switzerland that many other countries have too. In Germany, we see, for example, a tool that is helping in mass claims. You can have flight delays, or in this case, it was specifically for an emission scandal, where basically there are many claims where only the engine number is different or the year of purchase and so on. And these AI-based tools are taking the document and identifying and isolating specific areas or information, and then preparing already a decision that is then reviewed and finally taken by a judge. Or in Portugal, we see, based on ChatGPT, an interface that is guiding on divorce proceedings. This is not legal advice, though. Or in Spain, they have many tools, for example, also text transcription and others. So I think it's not only or always Estonia. There are many other countries that in very specific areas have very good examples how to use this technology and where to go. I'm talking a little bit about AI and digitalization that is used synonymously, I think, which is not very correct. And I showed you also the Gartner hype cycle, where you see on the x-axis the timeline, and the y-axis the expectations. And you see basically the expectations rose very steeply with the advent of AI and at the latest with ChatGPT, I think. But now the trajectory is coming down a little bit, and what we will reach in the end is a plateau of productivity where we have realistic expectations, not only on the domain of judiciary, but also on the technical possibilities, and then develop further these tools that are currently already being developed. So, but I think the AI discussion, we should be aware that this will annihilate itself at one point and become a little bit more realistic also in what is happening. Now, and in this regard, what we see already is that our member states are really trying to harness the opportunities of this technology, digitalization and AI, which is concerning issues of efficiency. So proceedings should be shorter. People want to do more with less. We talk about resources. Colleagues talk about a digital dividend. So basically, they don't have enough stuff but need to do the work, so the technology helps them. Issues of mass claims, there it's applied, where you get thousands of applications that you have to process somehow. And also in the investigation phase, where this technology is used, for example, for screening hard drives and so on. Basically, quality is the issue, doing things better, according to requirements and expectations. We see also that this technology can help us in the harmonization foreseeability of the law, in particular in case law research that is becoming more precise or comprehensive also, or also in the proposal in scales concerning sentencing and compensation in cases. Transparency also, I think, in the context of corruption or non-corruption is an important issue, so it allows us to use or introduce electronic registers that are accessible ideally. Interoperability is an issue, of course. Publicity can be increased, or also internally, what was mentioned, also management dashboards for looking at the life cycle of a case, basically. In general, we see that our members are using this technology successfully also to increase accessibility, in particular e-filing systems, the communication with courts, but also externally with the court users. We have remote services, remote hearings also. I think the advantages were mentioned by a citizen you interviewed before. And that was also very interesting because also at the beginning, so we also have to go in the judiciary with the expectations of the public. So it's also about convenience. We provide services and we have to meet also these expectations that applies also to other domains, of course, in a meaningful way. And this is also what we see, what is already happening. So it's not only about the efficiency, it's also about the expectations and the convenience. Now, talking about digitalization, that is all a bit ideal, but this is a process that has to be managed very carefully and critically, because there are, of course, some risks, and in particular with this direction, I think we have to avoid absolutely a digital divide, so the services must be available for all and be not discriminatory in one way or another. Digital services always have an issue of data protection, cyber security, and as mentioned before, no matter how the new procedure looks like or it's done, it must be in line with Article 6, the right to a fair trial. Talking about AI, which is often difficult to distinguish or differentiate in this regard, we have to be aware also about the deficits of this technology, and at the moment we're mainly facing black box systems. So these systems don't reason, they provide an outcome, but the reasoning is unclear, which makes the application very limited in the judicial domain, where reasoning is important issues. We're talking about statistical probabilities mostly, and the issue of bias, I think, is often heard, where based on historic data also new outcomes are generated that are not adequate. And if you follow the news, in particular with the advent of ChatGPT, we're facing also numerous risks of widely available large language models such as ChatGPT, where people, for example judges, use this outside their work tools, so to say, but nevertheless in the adjudication. And this, of course, has to be looked at very carefully. In the end, when we talk about algorithmic decision-making in general, what remains will be always automation bias, meaning if we support a decision, so also the human at the end is inclined to follow this decision. So that has to be looked at. And of course, ignorance could be a problem where people don't understand how these proposals are generated in the end. And when we talk about what future we want, in particular in this judicial domain, I would like to show you or cite two issues here. One of a Polish author who very clearly says, I want AI to do my laundry and dishes so that I can do art and writing, not for AI to do my art and writing so that I can do my laundry and dishes. I think that's it. We should concentrate not only at the pinnacle of the judicial task, but also at the tedious support tasks to make this work. And also another citation from another context was also that the development of these tools at the moment are often way beyond the problem we have in the judiciary, be it digital or not. And also there, in an analogy, one could say, when it was concerning radiologists, will AI replace radiologists? Is the wrong question. The right answer is radiologists who use AI will replace radiologists who don't. And I think this will also be a little bit the development that we're facing in the judiciary, that we don't replace the human, that we don't replace the judge, but we support the judge to make room for really the important work. To conclude this brief intervention, not becoming too lengthy, we definitely recommend, as the CEPESH, also to monitor the development very carefully, because it is very dynamic. And we also have to have a differentiated view, because we talk a lot recently about generative AI, but as I gave you also examples, there are other tools that are less critical, but also less inspirational, so to say. Nevertheless, they are very useful and most likely the future. We should also remain constructive but critical in the adoption of this technology. And as said already, we should have a conscious human-centered design and application choices. So it is really about where do we want to have this technological development, and how and where do we do not want it, for several reasons. And definitely what we must do is to include the judiciary in the decision. So this is nothing left only to private companies in this regard, or at court administration. Really, the judiciary also has to take an active role in this. And we would also advocate for regulation in this regard in a highly unregulated field, but which is out now. The Council of Europe, the Framework Convention on AI is open for signature since 5th of September. The AI Act of the European Commission is also out, and so more regulations are slowly coming in and will also change this field we are talking about. And what at least the Council of Europe regulation is asking for is an ex-ante risk and impact assessment of these tools that we definitely need for the judiciary also. And in this regard, the mentioned ethical charter on AI from the CEPESH, I think, is already giving a good guidance in which direction such an impact assessment could go. Definitely, we need also transparency about the applications of these tools, so that the users are aware that they are in use. And importantly, I think we need to educate the professional users, also those who make a decision on their use, of what that is and how it works. And that is a big challenge, but a continuous process. So with this, I think I would like to end this input to the discussion, and I'm happy to participate and also in the discussion later. Thank you very much.
Thank you, Mr. Schmidt. It was an interesting, in-depth presentation about what the artificial intelligence can do in the justice sector today. Thank you very much. I'm sure there will be a lot of questions in this section afterwards. Până atunci voi trece mai departe la doamna.
Until then, I'd like to give the floor to Tatiana Chaglik, member of the Superior Council of Magistracy. I'm sure that you have some thoughts to share about the use of AI in the Superior Council of Magistracy and beyond. Thank you very much for giving me the floor. Of course, we can use AI, and I'm glad that we're on the same length, so to speak, with the previous speaker. But before speaking about AI, I think we need to talk about the readiness for implementing such solutions. We need to have a transparent system, easy to apply by justice seekers, by users, for which e-file system has been developed. And after that, can we think of such tools, AI tools? Because in order to implement AI, we could implement AI for statistical reports. And we have Justat and the statistics of courts on the Superior Council of Magistracy's website. So perhaps it would be good to have a more thorough, more in-depth analysis of the statistics, which is not complicated to do with AI, and it would bring a lot of advantages because we'll understand what happens in the courts. And I'm sure that many court presidents and heads of secretariats will say that these performance indicators and reports help them better assess the work of the courts. And at the Superior Council of Magistracy, we'll look at this data and analyze it. But once we Okay, we're talking about AI, but before AI, it would be good to have a methodology for analyzing these statistics before implementing such tools. Now I'd like to mention the fact that we're meeting the second year in a row to discuss such topics, which means that now we're more and more aware of the need to talk about digitalization, AI solutions, and understand that this is a very important tool to combat corruption and to promote the justice reform. We're talking about EU integration, about CPEJ tools implementation, and we cannot implement them without technology. We need to ensure interoperability with other systems, including systems from the EU. And for that, we need to join our efforts. I'd like to mention the achievements of the Superior Council of Magistracy over the past year between these two forums. First of all, we strengthened the council, and we have a working group within which we have court presidents and judges from all three-tier courts. In this working group, we talk about challenges and provide the direction for the development of IT systems in the justice sector. We've had 8 meetings with the group. Usually they are held in the last Friday of the month. And the minutes of these meetings you can find on the website of the Superior Council of Magistracy. As the previous speaker mentioned, and as my colleague said, it's very important to educate courts when it comes to using IT systems. They are the ones who understand the needs of the courts and of justice seekers, and they are those promoting solutions and analyzing solutions that need to be implemented. And we implement these solutions with the support of our partners, of course, and I'd like to thank the Model Court project funded by USAID, and due to them we're able to implement the integrated case management system. We were able to work on the regulatory framework, which is very important because technical solutions should be in line with some regulations, legislative amendments. Of course, we need to have a broader discussion on next steps. So we thank the hosts of this event, including the Institute for European Policies and Reforms, with whom we worked on the e-file legislation amendments. It's now in pilot testing, and these technical solutions should be accompanied by a legislation. So we're glad to see the good feedback. And we'd like to reconceptualize the e-file system because this is a system for the interaction between justice seekers and courts. And by the way, this is a very important tool in the context of the court map reform. And we're glad that these video conference tools and solutions are being used. Even though the legislative framework has been amended and these solutions are used, they can be used even more. We could have more remote hearings via video conference solutions. And in the end, I'd like to say that digitalization should be seen as a continuous process. The future of justice is here and now, and to to achieve good results, we need resources, financial resources and human resources. And without these resources, we cannot advance, we cannot move on, and we'll just stay at the same level. But we cannot do that because EU integration will follow, so we need to be at the same level as EU member states. Performance indicators are separate tools, but I think we can go beyond that and implement other solutions. We'll continue working in this sector, and if you have proposals, suggestions, don't hesitate to contact us to make proposals and suggestions, because we are the ones making this digital justice. Thank you very much.
Thank you. It's very interesting. I'm glad that you have this enthusiasm to change, to improve the judiciary. I believe that we used to be 18 out of 20 in Europe, and hopefully next year when we meet here, our ranking will improve. These reforms are very needed, in particular in the judiciary, so that we can progress on our EU accession journey. Thank you. For sure, we'll have questions during the Q&A session. And we continue now with Nathan Brooks, international lawyer for hacking, informatic, and intellectual property of the U.S. Department. Mr. Brooks, I hope you can hear us.
I can. Thank you very much. I hope you're all able to hear me okay.
Yes, we can hear you perfectly.
Excellent. Well, it's wonderful to be here with all of you. I'm going to see if I can share my screen. But while I'm doing that, I want to make sure that I give you a little bit of background about who I am. I am a federal prosecutor based in the United States, and I am temporarily detailed to Eastern Europe as part of the ICHIP program, International Computer Hacking Intellectual Property Program, and we focus on capacity building with respect to fighting cybercrime in a very large coverage area that includes about 32 countries, and it includes Moldova, Romania, Ukraine, and I have been to all of those countries. I used to be based in Bucharest and got plenty of times to go to Chisinau, so I'm sorry I can't be there with all of you today. But I'm going to talk today about a couple of topics. I'm going to touch briefly on AI, a topic that I know is being covered a lot there today. And I want to talk a little bit from the U.S. perspective, but also about, if we're going to talk about the future of justice, I think it's really important to talk about proactive law enforcement operations and the ability of courts to authorize such operations or not, but to have the legal mechanisms in place for those. I think that is sort of the future in terms of the criminal justice perspective. So on the AI front, when it comes to artificial intelligence, you've heard some excellent presentations already talking about that, and I don't want to cover some of the same ground that they have, but one of the things that makes our system in the U.S. A little bit different than many others is the reliance on case law and the ability to reference prior case law, and how much of a huge part of our job as attorneys that is. As a prosecutor, if I'm bringing a case, a major case, I'm going to be writing a lot of briefs, a lot of legal briefs to the court, summarizing what the law is and what prior cases have said from our jurisdiction and from other jurisdictions as well. And this is one of the primary worries that judges in the United States have, is the relationship of AI, of artificial intelligence, to this process. Essentially, in our system, in our adversarial system, both the prosecutor and the defense attorney, or in the civil context, the plaintiff's attorney and the defense attorney or attorneys are all really there to help the judge find the truth, or the jury find the truth, be that as it may. And ultimately, I have a client as a prosecutor, which is the United States of America. the defense attorney has a client who's the defendant, and we are advocating on behalf of our clients, but ultimately our primary goal is to help the court find the truth in one way or the other. And the big worry in the United States over the last couple of years, as we've seen the explosion of generative AI models, is its ability to be a corner cutter for defense attorneys and prosecutors, or plaintiffs' attorneys and defense attorneys, any attorney with business before the court. The idea that instead of doing research, verifying it, ensuring what you're saying to the court is accurate, relying on AI to not only do the legal research, but to give the legal citations. And Chief Justice John Roberts of our Supreme Court last year issued a report kind of summarizing his concerns about that. And then also there have been any number of law review articles talking about how AI offers so much promise in terms of access to the court system and court decisions in the United States, but also the danger that it can present in terms of misrepresentation of information to the court. And to that end, in the United States, over 20 different district courts have issued standing orders with respect to artificial intelligence. And the general idea is that if anybody before the court, any attorney licensed to practice for the court, submits a document with any use of artificial intelligence, by any way whatsoever, he or she must note that and tell the court exactly where that is and how it was used. And again, if you've ever looked at an American brief from a U.S. court system, it's replete with cases and summaries of those cases. And while obviously artificial intelligence can go a long way towards maybe summarizing or pointing an attorney in the right direction as to where the right case law might be, relying on it to accurately summarize what is can be a very esoteric concept is a problem. And it's something that concerns courts greatly. And this is one of the major reasons why we have all these standing orders in the United States from courts. And I think, reading between the lines, I think it's meant to discourage attorneys from using artificial intelligence past the initial step. The way I would probably liken it to is if you were going to do research on a topic, not legal, just any topic, you might pull it up on Wikipedia just to sort of see some other sources, or might see what the general idea is, but you're never going to rely on Wikipedia in any way, shape, or form. I think that's maybe what the judges are hinting at in the U.S. If you want to use AI at the beginning to sort of point you in a certain direction, maybe point you to some cases that you can then look up and determine what they actually say and write your own legal brief, I don't think that would be an issue under many of these standing orders, the way I read them at least. But it's when you start using them substantively in your briefs that it becomes a huge issue. And I think we're going to see a lot more cases where that happens, where someone's able to determine that some sort of generative AI was used in writing or largely researching a legal brief. But I think it's something we're still going to sort out, and I think a very fascinating area of law. I mean, I'm in the U.S., one of my favorite things to do is to write legal briefs and to do legal research and then to argue in front of a court based on that. And I would be very interested if I came across a situation where I was pretty aware that a defense attorney or my opposing attorney had relied on artificial intelligence in some way. It would definitely present me with an interesting decision before the court. But so I want to shift from AI if I can for a moment, because again, it has been covered and will continue to be covered well by my colleagues on this panel, and mention the court's ability to authorize or deal with proactive law enforcement operations. And what I'm talking about here, and again, I really do think this is the future from a criminal justice perspective. We, as prosecutors or law enforcement, are increasingly running up against walls when it comes to, like you see in front of you, major ransomware variants or malware variants. In that in many instances, it's going to be very difficult for us to arrest anybody or physically put handcuffs on an individual, because many of these folks are located in countries where we cannot extradite them. They won't extradite their own. But one thing we do have the ability to do, as we did in this lockpick ransomware case you see here, is to disrupt their infrastructure in some way, remotely. We do have the ability to do that. In this particular case, we actually were able to get information related to the decryption keys that are associated with this particular ransomware. And this is all public information that I'm releasing. This is not anything super secret. This is information that's been in the public sphere by the United States Department of Justice, my employer. And I use this here as an example of an instance in which U.S. law enforcement, together with global law enforcement authorities, our partners, were able to disrupt a particular malware / ransomware variant remotely, and to even help victims out on their own computers with decryption keys. That's separate and apart from making an arrest, which sometimes we may not be able to do given where these countries are. And as I'm going to talk about for the next few minutes, this is something that's a unique creature in American law. We have the ability to do this based on some of our the amendments that have happened to our search warrant process, and I think it's something that courts need to be able to at least be aware of in other countries and figure out, do they have the ability to do the same thing, and if not, why not? The ransomware variant that I think might be interesting for all of you is a very recent one called Volt Typhoon. This is one that, based on public source information, was essentially, we believe, and many private sector folks believe, is traced to the People's Republic of China. Essentially, over the years, they were using what's called living off the land methods to enumerate critical infrastructure, in particular in the United States. And when I say enumerate, what I mean is they were going into various private sector and public sector systems using tools that are native to those systems. That's what we call living off the land. They're not necessarily using malware once they're inside the system, although they can. But generally speaking, they're using things like PowerShell or other techniques, legitimate techniques on a computer to determine what is on those systems in the event they might need to use that information later. And so this was labeled by Volt Typhoon. And what we saw with Volt Typhoon, again, according to a lot of publicly available information, was years and years of reconnaissance, accessing systems they had no right to access remotely, and essentially looking around, trying to determine where critical infrastructure was in the electronic sphere. They were able to compromise remote access points, and then also compromise end-of-life old VPN and routers that are still out there. The Internet of Things is a lot like any highway that you go out to. You might see some nice new cars on there, but you're also going to see a lot of old, out-of-date cars. Routers and VPNs are the same way. There's a lot of routers and VPNs out there that have no updates for them, haven't been updated in years. They're never going to get updated, and those are prime time targets for attackers, as they were here. And using those and many other resources, the Volt Typhoon group was able to access various aspects of criminal infrastructure in the United States, even using what we call a botnet, which is essentially a command and control device to be able to control various other computers that don't realize they're being part of this network. It's very possible that people in this room, you've been accessed by a botnet previously. Your computer is used to attack other computers without you knowing it. If you've ever had your Facebook account stolen and you notice that messages are going out from your Facebook account without you authorizing it, or messages are going out from email without you authorizing it, that's an example of a low-level botnet. It's the same type of thing. Someone uses your computer, you being an innocent bystander, to perpetrate attacks on other computers. And that's what was often going on here with Volt Typhoon. And so they use a lot of different techniques, and what they're trying to get to is credentials. Oftentimes what attackers in these cases are doing is trying to get into a computer through any access point and then elevate their privileges and try to get a hold of credentials, admin credentials, administrative credentials, to be able to get higher access. And in Volt Typhoon's case, this is where they wanted to get. This is the command line in any typical computer. I'm sure you've all seen this on a computer. It's the old school command line Oftentimes on a server, it's going to be written in Linux. You might be using PowerShell in a Windows system, but it's the basic command prompt for a system. And this is what was often happening in the Volt Typhoon situation. They wanted to get to this command line and be able to look around our critical infrastructure to find credentials or find out how our systems work at the public and the private level. And ultimately get passwords as well. There are various tools out there for cracking passwords. You get the file that has the hash value passwords for a network. If you get it offline, there are any number of tools that eventually will help you crack those passwords. And that's the way it was working. So again, in many situations in the US, when we're confronted with a botnet, which is of course, many computers that often don't realize they're being used nefariously, or simply you have a large computer network. The question is, how do you actually go after some of that infrastructure? Again, this is separate and apart from finding the bad guy, which is of course our #1 priority. But we also want to be able to disrupt their network and maybe even remove the malware from the victim's computer remotely. Well, in the US, that was a huge problem. We had the ability under our case law to do it, but the problem often went to a more procedural level with venue. If I'm located in my home jurisdiction, but I know that a botnet is operating through 50 different jurisdictions in the United States, the old case law would have meant that I would have had to get 50 separate search warrants in all those different jurisdictions. Well, our Rule 41 for search warrants was revised to make it so that I could get one search warrant in one jurisdiction that was affected, and we could act against this group in any jurisdiction. Similarly, this also the revisions to Rule 41 also allowed us, if we didn't know where a certain group was located, to be able to use electronic means to determine that. And these things really helped us out from a venue perspective. They removed some of the impediments that were in Rule 41 that, of course, had been written before we had things like botnets or even the internet. So we had to make sure that our search warrant rules were kept up to date, or at least up with the most current technology. And so we have that ability now. We have that ability to take down and go after infrastructure as part of our search warrant process. Again, separate and apart from gathering evidence or going after the bad guy. We even have the ability to remove malware, ransomware from a victim computer. So a search warrant in the United States under our case law can be executed with respect to victim property as well. Our case law essentially says that if fruits or instrumentalities of a crime are more likely than not to be found at a given property, we can search it, or our law enforcement can search it, whether or not it's victim's property, whether or not it's a bad guy's property. It's really just, is the instrumentality of a crime going to be found there? And in this case, it's malware that's been infected on a victim's computer. We can get authorization to remove the malware from that victim's computer. Again, when you're talking about hundreds or thousands of computers, this is really, really valuable to help us to do. And the proactive measures, in addition to things like removing it, we can set in the Volt Typhoon instance, we sent botnet commands to the routers that were comprising the botnet itself. Our guys would not have gotten any response if these servers or these VPNs were not part of the botnet network. And so that's, once they respond, we know they're part of it. Also allowed us to gather IP addresses and port information for communicating with the infected routers to help us try to identify where the bad guys were. And then, as I mentioned earlier, we could also send commands to remove the malware from the infected routers. And when I say we, I mean Department of Justice writ large. This was not my case, but these were the things that the court authorized the United States law enforcement to do based on the search warrant here. So hopefully the question for all of you is what kind of, on the AI side, obviously, what kind of rules do you have in place to make sure that the judges or judicial officials are not being misled, and that those who have a duty to inform the court are doing so properly if they're using AI? And the second of all is can a court in Moldova, can a court in any country in your region authorize actions to disrupt through law enforcement means a botnet network or a ransomware attack network or would they be hindered in some way? And does that hobble your ability to fight this type of crime? So that's all my presentation. Happy to take any questions now, but I really appreciate the opportunity to be part of this panel. I really enjoyed the presentation so far.
Thank you, Mr. Brooks. It was an interesting presentation about what also digital tools can do in a harm way. So thank you very much for the presentation. I'm sure there will be a lot of questions in this following section of Q&As. Dar până atunci o să trecem la...
But before that, let's continue with the next speaker, Andrei Ojoca, judge at the Chisinau court. In the information we received about you, we understood that you are a pioneer in implementing digital solutions in the justice process, and I hope that you will share with your experience and tell us how you see the future of digital judiciary in the Republic of Moldova. Thank you. I am trying to be a pioneer. I became a judge in 2018. Back then, one of the first things that I did was to create an electronic agenda for me. I used to work previously as a court clerk and then a court assistant, head of the procedural recording and documentation department, and they have never understood why the judge has to have a paper-based agenda and why it has to include data about the same case for a number of court sessions. And because I had experience in cooperating with the CPERJ team, we prepared an electronic agenda in Excel format, and back then I understood that I cannot create an electronic agenda in other applications such as Google because of information security reasons. Starting with July the 1st, 2018, I started to use massively electronic signature to sign various court documents such as resolutions, judgments, public summons, notifications, and I promoted this idea for court users to use the electronic file in order to store or send for example, the public summoning to be published in the newspaper. Since 2024, I started to use heavily Zoom for court hearings via video conference. Since 17th of January 2024, I have already had 16 online court hearings, including in hybrid format. About 17 persons attended them, of whom 14 are lawyers. In this process, I have noticed a large opening by lawyers. So using this opportunity, I would like to thank them for supporting me in this endeavor, because they somehow contribute to promoting this idea. So far, online meetings were held on 10 cases. To make it clear, I am working as a judge, and I review civil cases. Recently, I started to use the text dictating application. The last time when I used this tool was when I prepared a court resolution on 37 pages. So when I was working with a case, I reached the conclusion that it's not worth typing that text. That's why I used this tool. I understood that we need time to adjust ourselves and learn and feel comfortable in using these tools. In my daily work, I also try to use text reading applications. It's very comfortable. In addition to reading the case file materials, you have the possibility to listen to it. Regarding the integrated case management program, since I started my work as a clerk, I've tried to contribute to the development of this information system because I have never understood why we had to make so many clicks to get a result. Meanwhile, things have evolved, they have changed, and I am glad that certain recommendations that I made were implemented for the whole country. Now we already have certain results, but as I usually say, we can never be perfect. We should always keep on improving. As I told you, I made a number of recommendations. For example, I still do not understand why the clerk from my team needs to spend so much time in order to send a request or a summon to a state institution. This should be done automatically. This should be done in real time. When you appoint or you set the court session in the application, then the application should send out summons automatically to the respective institution. Regarding ongoing or continuous digitalization, we all want it. For example, the Chisinau court perhaps is the only court in the Republic of Moldova that has access to 5 registers via the semantic catalog. This was possible thanks to the fact that the management of Chisinau court was insistent, and this is a good start to improve the judges' access to registers. What else I could tell you? In my daily work, I have noticed one thing. For example, the clerk, when generating the list of court sessions, he or she has to choose every time the name of the judge. This was eliminated previously because the clerk is working with a judge for a longer period of time. So I believe they should not select every time the name of the judge, because these couple of seconds they spent for doing it are not spent soundly. So there are some minor technical issues that have to be improved until we start implementing artificial intelligence in the court's work. I have been always promoting digitalizing court's work. I believe that this will facilitate our work significantly, because we cannot do it otherwise. If so far the number of judges has not increased, then I believe that in the future it will not be sound to increase the number of judges, because if we implement correctly some digitalization and automation tools, then the need to increase the number of judges will disappear. And yes, there are a lot of discussions about using artificial intelligence. How do you think, myself as a judge interested in digitalization, automation of court work, have I used artificial intelligence to prepare court documents? Well, I can tell you yes. I generated the reasoning part of a court judgment using an artificial intelligence. I will not tell you the name in order not to advertise for it. It was a very simple case. It was a litigation on the collection of a debt on the basis of a loan agreement. I entered the needed data. I studied the case file, of course. I typed the solution, and I uploaded the template. So when I told the artificial intelligence to generate the final document, it was generated. Now I am testing in order to understand how we can use IA in our work, in my work in particular, so that I simplify my work. There are some things that can be simplified by implementing correctly IA. I believe that the judiciary is open to automation, but this should be done in a correct way. So if we, as a society, will manage to create certain conditions for internal users of the judiciary, when they see that, look, if I send the summons online via email, I save money, then of course that person will start using email to send summons to other participants. So that's all I wanted to tell you. If you have questions, I'm open to answer them at the Q&A session.
Thank you very much. As far as I know, there are judges with hundreds or even close to 1,000 cases that they need to review. So it would be good for them to use digital tools to enhance their work and make their work faster. But we'll talk about this in the Q&A session. Before that, I'd like to give the floor to Miriam Stankovic, Senior Principal Digital Policy Specialist at the Center for Digital Acceleration, DI.
Thank you. So based on what was said previously, this is going to be a deep dive on AI and all the opportunities that come with AI, but also the challenges that come with AI. And how it's being implemented all around the globe in the justice sector. What I would like to underline in this presentation is that AI is not a monolith. So I hear a lot of times, often people referring to AI as just one thing, but it's not. So as you can see, AI can mean a lot of things. It represents a spectrum of technologies, and each technology is suited to different tasks within the justice sector. So some of the discussants, the previous panelists, they mentioned, for example, the case of ChatGPT. ChatGPT is generative AI, but there are different types of AI. We have natural language processing, which is used by both judges and justice sector institutions all around the globe. To help with the review of legal documents, case files, precedents, and this enables both lawyers, judges, prosecutors to process vast amounts of information quickly and accurately. AI is being used in risk assessments, for example, for recidivism, and also AI can be used in content moderation. For example, it can aid in transcriptions, it can flag inconsistencies, it can detect fraudulent claims made in pleadings, and this can increase the reliability of evidence in court proceedings. As with all applications, digital applications, AI in particular, it is essential to implement strong, robust ethical frameworks in human rights, lens. To minimize the bias and ensure fairness in the justice sector if the justice stakeholders start implementing certain AI applications in their work. Here I give you the key blocks of artificial intelligence and different types of AI technologies. So we have algorithms, and we have data. And here on the slide, you can see that, data can be digitized. So we take like a document and then we digitize it from paper into digital format. That's digitization. But AI can be also generated. Some of the panelists mentioned, for example, the Internet of Things. That is, data that is already generated as digital. You can see, social networks. Through social networks, we generate even not being aware of this. Every minute of the day, we generate a lot of data, and devices also generate a lot of data. And that's the process of datafication, and this big data that feeds into AI systems and enables the AI systems to make decisions and to predict certain scenarios. Also, when I said AI is not a monolith, it means that AI can run on different, mathematical operations and algorithms. The riskiest of all, in terms of its implementation in the justice sector, is algorithms that are self-learning. So we all heard about machine learning. So machine learning, and some of the panelists, they mentioned black boxes. Usually we encounter black boxes. Our inability to understand how an AI system operates when it drives on machine learning algorithms that are self-learning. So it means that the human is far removed from the AI loop. So these are the challenges in AI application in the justice sector. So here I have given you certain applications of AI in the judiciary. We don't have much time to go in depth into each and every application, but I'll try to do my best in 15 minutes. So we have e-discovery and document review. So AI can be used for that. It can be used for predictive analytics. In here, again, everything that comes with prediction or risk assessment is noted as high risk for violation of human rights. Then dispute resolution, language recognition and analytics, and digital file and case management. With respect to e-discovery and document review, AI has been used in criminal or civil cases. It can quickly sort through vast amounts of data, of digital evidence. When we say digital evidence, we mean emails, financial records, social media posts, and we can use AI to identify only the relevant data. For instance, in a corruption case, AI could zero in on financial documents and communications that indicate fraud. And then once AI identifies the key information, it ensures that it is properly preserved and collected in line with legal standards and in line with safeguarding the integrity of digital evidence. And then AI algorithms could be used to group similar documents and to conduct concept searches. For example, in criminal investigation, AI can reveal patterns in communication or financial transactions that suggest illegal activity, and this can help prosecutors build a stronger case. So by using AI in e-discovery, the justice system can handle increasingly complex and data-heavy cases more efficiently, and we know that a lot of judiciary systems around the globe deal with a lot of inefficiency and backlog, and hence digital transformation efforts, and also the use of AI in the justice system. Now, predictive analytics and ADM, automated dispute mechanism support. So here again, this should be everything that comes with predictive in front of the term. The judges and prosecutors and justice sector stakeholders should approach with a lot of caution, because it entails a lot of risk, as I already mentioned, because most of these systems they use self-learning algorithms, and they can perpetuate bias, and also they are black box systems. It means that both judges, justice system stakeholders will have a hard time understanding how the system operates, and this can be a huge challenge, and I would caution against using these systems in the justice sector. And here, when it comes to predictive analytics, there are certain types of applications such as forecasting, case decisions, and there are a plethora of AI platforms that do this, such as Lex Machina. Predictive analytics in online court platforms that offer guidance to individuals that navigate the legal system. For example, tools like Do Not Pay, which automate claims for minor legal disputes and make legal resources more accessible, especially to vulnerable or underserved populations. Then there are certain ODR platforms such as SmartSettle or Modria that use machine learning algorithms to help parties resolve disputes. AI can be used for automated legal guidance. We've seen AI being used for generating documents, contracts, trusts, etc., etc. And the most controversial uses using AI systems for risk assessment. And there's been a huge controversy here in the United States, where AI-powered tools such as Compass supported judges in assessing the likelihood of a defendant reoffending by analyzing various factors. And although these tools were designed to aid in decisions on bail or sentencing, concerns about racial bias have emerged, and this underscores the importance of having human in the loop. So someone that is going to oversee human oversight and ethical implementation of such systems. Another application of AI can be in the language recognition and analytics, it can be used for streamlining document analysis. It can enhance multilingual capabilities, and we've seen a lot of these initiatives, which are wonderful, by the way, in India and all around the world, where different languages are being used, so that this could assist with the functioning and the efficiency of the justice sector. And there are different types of applications and areas of applications. It can help with automated document analysis, multilingual translation, accuracy. It can help with identifying key legal entities such as names, organizations, or specific legal terms. And it can also increase, enhance redaction capabilities by automating the removal or sensitive or confidential information from legal documents. So a lot of excitement around the use of AI in this respect. AI, as previously mentioned, it can also assist in digital file and case management. And here I give you the example of Prometea. Is an AI-powered legal tool designed to assist judges, legal professionals, and decision makers by automating various judicial and administrative tasks. It was originally developed by the Public Prosecutor's Office in Buenos Aires, Argentina. Now is used across several legal systems worldwide, and it helps streamline court processes, improves efficiency, reduce the workload of legal professionals by using machine learning and natural language processing. So, so as you can see, there are a lot of cases of usage of AI in support of the work of the justice system. We just need to do this responsibly and ethically. Here I give you case studies on AI deployment in the justice sector, in the justice system, all across the world. So I mentioned Argentina and Prometea. There is the case of Brazil. Victor, an AI system that analyzes a high volume of appeals and automates the examination process to identify certain types of cases for the attention of the Supreme Court. Then in India, they have this SUPACE AI system that catalogs judicial decisions to aid in the administration and delivery of justice of the Supreme Court and also high courts. There have been also uses of AI systems in Colombia, Singapore, UK, for example, for risk assessment or suspect probability of reoffending. So a lot of usage of AI in different areas of the justice system. Now, we don't have much time, but we need to go beyond this excitement. And some of the panelists have mentioned the challenges that come with AI, and I would like to identify the biggest challenges. Two big challenges are AI bias. AI bias, algorithmic bias is a really important issue if you considered introducing AI into the delivery of justice. Algorithmic bias refers to the systematic and unfair prejudices that occur when automated decision-making systems produce discriminatory outcomes. It can be that the data that goes into the system is biased. It can be that the AI model design is biased, and this can have severe repercussions for human rights in the justice sector. It can lead to biased risk assessment, flagging people of color, brown or black. Unfair sentencing decisions. It can also be biased towards minorities and other vulnerable or marginalized groups, and it can perpetuate existing inequalities, not just in the criminal justice, but in the overall justice system. So we really need to approach the issue of implementing AI into the justice sector with careful data protection impact assessments, algorithmic impact assessments, in order to evaluate how this systems would impact certain demographics and populations. So I've already spoken about this. This is also another typology of bias that go into AI systems. Here I give you the spotlight on predictive policing. Is an area where algorithmic bias has caused a lot of concern and controversy. One of the most well-known examples is the use of strategic subject list in Chicago. This AI-driven tool was intended to predict individuals who were likely to commit crimes based on historical data. But guess what? The historical data was biased towards Black and Latino communities, which had already been subject to disproportionate policing, and these communities were further targeted by the AI system. Okay, so a vicious cycle. And this led to increased surveillance and policing in these communities, perpetuating the cycle of over-policing. So we really need to be aware of these challenges. And then AI systems as black boxes. This is also very important. It means that the system either the designer of the system cannot understand how the system works because it runs on self-learning algorithms that change over time by themselves, or the firm that's still the system, that's the vendor that sold the system to the government entity, for example, to the justice institution that uses the AI system, will not reveal the workings of the system because of intellectual property concerns. And this is also we need to be aware of these issues. That the black box is really important. So whenever we think of implementing AI in the justice sector, we need to think about implementing systems that are explainable, okay? White box AI systems. And this ties into issues of algorithmic transparency and algorithmic accountability. How governments are dealing with the issues of algorithmic transparency and accountability. For example, in 2021, UK published the National Algorithmic Transparency Standard. Several cities have implemented public registers that describe algorithms that are used by municipal administrations. In 2022, a remarkable achievement, Chile proposed regulation to become the first Latin American country to adopt algorithmic transparency standards. This has been done either through standards or through regulation. And algorithmic accountability, if algorithmic transparency is what, algorithmic accountability is a step further, and it shows the how. Okay, so whether we have robust procedures and not just publishing the algorithms that are used by public administrations or the justice sector stakeholders in their work when they implement AI systems or automated decision-making systems, but also showing the how. What is the potential for human rights harms? How do we determine liability when an AI system is used, and whether the results of the AI systems and the design are also explainable. So that's algorithmic accountability. And I would conclude here with several recommendations for implementing AI in the justice sector. So first and foremost, the use of transparent and accountable AI systems. That's very important. You should implement, if you decide to implement AI into your into the delivery of your activities, then you should make sure that it's not the data, the system design is not biased, it's not a black box. You always have human in the loop or human oversight and meaningful human control. This is very important, especially in the justice sector where human rights are concerned. Most important, at least according to my professional experience working with different governments around the globe, is that there should be comprehensive capacity building. So training, education, always explain what the limitations. Okay, so we're very excited. These are all new technologies, but how do we use them responsibly? Because people use them, okay, so that's the reality. But then we need to also inform people about the challenges and difficulties. Some of the panelists mentioned data governance, privacy protections. Always when AI systems are included, try to conduct data protection impact assessments and also foster collaboration and stakeholder engagement. Engage with the constituency, engage with the private sector if you work with the private sector to develop and implement AI systems. Now, I would finish with just pointing to the Global Toolkit on AI and the Rule of Law for the Judiciary, for which I was the principal author. It was published by UNESCO, and I think it contains practical guidelines with respect to the use of AI in the justice sector. And with this, I'm going to wrap up. Thank you so much for your attention.
Thank you, Madam Stankovic. It was a very balanced presentation. You talked about how we can use better the AI in the justice sector, but also about the biases of the AI and still mitigating those biases. So thank you very much. Vom trece acum la sesiunea de...
Now we'll move on to the Q&A session, but before that, I'd like to establish certain rules. First of all, tell your name and for whom the question is. And if you address comments or answer the questions, please don't be longer than 2 minutes. Now I declare this Q&A session open. Now let's see who'll break the ice in this afternoon. We have a mic next to the stage. If I may... Yes, Mr. Kirtaka, please. Thank you very much for the presentations, fantastic presentations. And I'm really glad that you covered a big part of this ecosystem of digital tools and AI. My question is both simple and complicated. I wanted to ask practitioners, namely Mr. Ojoga, what do you think are the segments, aspects in your work that can never be subject of digitalization? Because I'm sure that there are certain elements that cannot be subject to AI, to digital tools, because they don't have the characteristics of a human being. And another question, we'll see whether it will be true in 5 years. Thank you for your question. If I was able to fully implement the e-file system with no paper, I would do it, and I could describe every step to every staff of the court, and I can honestly tell you that we can use the full e-system. We don't need the forms, the paper forms. We don't need the forms for designating the cases. We have a lot of prospects for the future, but this trend of digitizing the work of the court work is fragmented. In my opinion, the Superior Council of Magistracy should be the engine, should be the engine that drives this field and bears the burden and encourages the colleagues and other institutions and creates conditions for this digitalization. We can speak a lot about digitizing cases in courts, but if we don't collaborate and coordinate with other state institutions, will not reach a fully digital system. I think that we can have an automatic distribution of cases, the receival of cases, and we're working in this direction, and we'll see how things move on. And depending on the results, we'll come up with concrete proposals and suggestions. I was talking to some of legal professionals on different categories of cases. And in my opinion, 30% of simple cases can be digitized, can be processed automatically, and they can only be monitored by a judge. We cannot automate high complexity cases, very complicated cases, because when a person comes to you, you create a profile within several minutes, and you understand which is the direction you need to move towards, and you understand what are the questions you need to ask in order to hear the truth. So for these categories of cases, I don't think we'll be able to automate our work, but we can make our work easier. We can make the work of course easier in these complicated cases. And I think that simple cases can be automated. And this is my opinion. I've said it before. Myself as a judge, I'm a judge for certain people who come to me with regard to a case. Those citizens, those people, tomorrow will become my judges, because together with the entire society, they will judge me on my manner of work, of processing the cases. Now, when we have digital tools, we need to use them to the benefit of the judge, so that the judge can be even more correct, even fairer. Someone previously said that these huge amounts of information are difficult to be processed, but AI can help us store and process the information that we need for a certain relevant situation. I, as a judge, am interested in the portal of courts to represent or to describe cases that were not quashed, because they are not relevant for our work. And I could tell you a lot if I go into details, but I think that we need to have an e-library for judges, and this should be used with the support of AI. I, as a judge, should obtain my information very quickly. I shouldn't spend time to look up some information, because the time that I spend is at the disadvantage of others. The quicker I access the information, the better I do my work. Thank you very much for the question. Thank you. Yes, please.
That's a very good question, and immediately I made a parallel to the AI and my speech. So let's admit that using AI, for example, you can ask ChatGPT or prepare a speech for, and you give the information. And imagine that ChatGPT would prepare a text for me, and I would come with it here, and without reading it beforehand. And imagine, well, I would not trust it to come here and read it for the first time without proper preparation, but developed by AI. Not to speak about a court judgment that decides the destiny of a person. So my opinion is that we have to automate processes but we need to have limits. Yes, we need to use automation, we can use artificial intelligence, but we should use humans as well. Regarding a question whether a judge can be replaced by AI, I think no, at least not in the close future. Maybe in a distant future that would be possible, but I think it's a very distant future. Are there any other questions? We can take questions from the online viewers, but please tell us for whom you ask the questions. So if there are no questions, then I will use my position of moderator and I will ask you, Mr. Popescu. You spoke about challenges and you focused on the financial side and on logistics. You also assessed your needs, what needs you have in order to develop the... Have you made assessment? What would you need to digitalize the judiciary? Thank you for the question. All of us know that human resources are the most important. And irrespective of how many funds we have, unless we have proper people appropriate for their job, we will not manage to cope with our tasks. We made an assessment considering the competences of the newly established agency, and we concluded that we need 63 people. I would like to tell you that other ministries have had IT departments for many years already, and they have hundreds of people. There are ministries that have 400 people. Of course, they have more information systems that they are managing, they have more responsibilities, but it's important to have the appropriate number of staff. And I have this question: why the Ministry of Justice, that has so many important processes to take care of, should limit itself to a small number of people? The staff of 63 people for the new agency is the minimum that is needed for a preliminary implementation of its tasks. We understand that once this agency is established, we will not be able to recruit and fill in all of the positions overnight. And also we will need to find the right approach to attract them, because if we paid them the current salaries of 7,500 lei per month, we'll not be able to attract IT specialists. So we see this process as an ongoing process. We would like to establish the new agency. Then I understand that we'll have to put in place some mechanisms to amend the procedure of attracting, recruiting, and remunerating our staff. Other questions? If not, I have a question to Mrs. Chaglik. There are a lot of discussions about cutting corruption by digitalization, meaning that a person does not have direct contact with officials. Can we have a similar situation in the judiciary? To decrease the risk of corruptions, because if processes are not digitalized, then court users will have more interaction with the court staff. I see things different, but it's interesting how you have formulated this question. When we speak about digitalization and fighting corruption, digitalization means transparency. It means that any action can be logged. It can be seen who did this action and where. Then you can check what happened on a case. Who did that action, when, and from where. And by removing the possibility to make certain actions that are not reflected in the program, we'll have the possibility to check. The integrated program have logs, so it's possible to see all of the actions of each user. In addition to that, all of the judgments and conclusions are published. And also we use the electronic signature, so we can see when and at what time the document was signed. Transparency. So everything is published, everything can be seen, and I am glad that we had some discussions about publishing judgments, anonymity. An electronic course has been recently run on this topic. We are aligning ourselves to the EU standards. We have a regulation that replaces an older one, but here we have to review, we have to make the necessary adjustments, we have to keep on working in order to ensure more transparency. So these are the main features that helps not fight, but eliminate corruption. It's not possible anymore. But again, we have to speak here about the certainty of users. There is some reluctancy. For example, what happens if I make a mistake, if I have typos, I will be regarded as a criminal, for example. No. During the trainings, we always say that it's important, well, if you do not know, you have to ask how this should be done, because there are guidelines in the integrated program. There are also trainings. There is a program manager. So it's okay to make a mistake. It's human to make mistakes. Because in such complex programs like the integrated information program, it's impossible not to make mistakes. As the judge said, why there are so many messages that you need to make a click, then another click, then another click? Because in the previous versions, many errors used to be made, and they had to be corrected, and people would freeze, and this would create kind of bottlenecks. That's why these messages were introduced. Are you sure that you checked? Do you really want to save it? Of course, this will be upgraded in time. I believe that over the past 15 years of digitalizing the judiciary, these technologies proved that we can use them to retrieve data, to use data, to check data. The Superior Council, the agency, has access to this data. The judiciary inspection has access. Of course, all of these checks are visible. You cannot enter any case. You cannot have access to any information. There is a protocol in this regard as well. And of course, this information helps us monitor the work, and we can make a step further. For example, if we speak about fighting corruption, then this will help uniformize the judiciary practice. A lot of discussions were around the use of AI and predictability of judgments. This will not affect the judges' creativity, but will save time for repetitive works. As my colleague mentioned, libraries, that's a very good idea, but resources are needed to implement it. And this again helps fight corruption, because the justice sector will become more predictable. That's normal, and we all want it. Even this case file, where each user will be able to see what act was submitted, when it was submitted, what happened with this document, when the judgment was uploaded, when the summons was sent, and so on. In my opinion, this transparency, this possibility to check, is a guarantee that things were done correctly and in line with the procedure. And of course, we can go further, but as I've said, now we have to make sure that this minimum is implemented in all courts. This will ensure efficiency for judges, for staff. So we need to make sure that everyone has equipment, access to internet, access to software. If you have any technical deficiencies, then you need to get an answer quickly. And if you need trainings, to have those trainings available. And I would like to say that there are many tutorials, many guidelines in the integrated program. In each court, a specialist was trained to provide support for the whole court. The National Institute of Justice is providing trainings twice a year for judges, for the court staff. So I see that in such a way technologies help us fight corruption. I have a question for our guests from abroad. For Miriam Stankovic.
I want to ask you, how do you see that corruption can be tackled here in Moldova with the usage of the artificial intelligence, in your opinion?
Well, as I already mentioned, and this was also mentioned by most of the panelists, AI and digital technologies in general could increase, accuracy, could increase accountability, could increase transparency, because you have data, the data is logged into a system, the system is accessible to certain stakeholders, and everything can be tracked, and digital transformation, digitization, and AI in particular can contribute towards this. As I already mentioned, I would caution against using AI technologies that rely on self-learning machine algorithms for predictive analytics, especially if this is deployed in risk assessment. So we need to have human in the loop, as already indicated by some of the panelists. What does this mean? It means that the final decision maker is the judge, the prosecutor, or whoever uses the AI technology. Another plea that I would make with all the stakeholders that are present here is that they become aware that there are different types of AI technologies, and different types of AI technologies have different repercussions on human rights. Using AI, yes, it can be used to fight corruption, and as all digital technologies, it can contribute to transparency and accountability. And I already indicated that certain cities and also governments have started implementing AI transparency, AI accountability standards, as well as publishing the algorithms that are being used by, for example, municipal administrations on the internet, so that these algorithms can be accessed by citizens, by civil society organizations. Now, this is not very practical, because most of us are laymen, so we don't understand these technologies. So we have to have certain technical background to understand. So this means transparency, but whether we can challenge what's there, that's another topic for discussion. So the first step is to publish the algorithms that are used by the judiciary, by justice stakeholders in their work. Also, I think another thing that we need to differentiate, two things that we need to differentiate between is the use of AI by an institution, and the use of AI by the judge, by the judges themselves. So if a judge uses ChatGPT or another generative AI program, this is not an institutional use of AI, right? So we need to also distinguish between these two matters. Now, with all the fascination of generative AI, and we didn't have much time to tackle these challenges, I think that AI systems, as some of the panelists noted, can be these generative AI, for example, ChatGPT, can be used to ideate, to tinker, to design a speech, or something which is benign. But when it involves rendering a decision that might affect someone's life, we need to be very careful, because these generative AI systems, ChatGPT is prone to hallucinations. So they invent something that it's not there. Okay, so they might speed up some precedents or case law that is not there. They might invent a regulation that does not exist, and it's there in the text. So the final decision maker, the final stakeholder that bears the responsibility of what's in the decision should be the judge. And also, I would like to highlight that these generative AI systems are nowadays omnimodal. What does that mean? It means that they can generate text, large language models, but they can also generate pictures. They can also generate different types of media. So this complicates things. It involves security, it involves safety, it involves data governance, and it involves intellectual property, especially copyright issues. So yes, not to complicate things, AI and AI technologies can be used for transparency and accountability in fighting corruption. It can be used for sifting through large amounts of data that can be published on the internet, but we need to move we need to move beyond that, not just publishing the data and making things transparent, but also making the things understandable for the public, for civil society, and for the citizens. Over. Thank you.
Thank you very much for your answer. Avem și o întrebare.
We have a question from an online viewer. In your opinion, from a realistic perspective for the Republic of Moldova, do you think that we might have a digitalized justice in the future? So that's an open question. Anyone can answer it. Of course it's realistic. It's very realistic. Why shouldn't it be realistic? But again, as I've said, it depends on us whether this justice will happen today, tomorrow, in 5 or 10 years. So I want to say that it depends directly on the investments, though it sounds pragmatic, because digital justice is a product that costs efforts, time, money, because all of these resources have to be in place to make it happen. And as my colleague Mrs. Popescu mentioned, we need IT specialists, but in addition to that, we need other types of specialists that will be able to understand the criminal proceedings, to understand the law, and to be able to translate legal language into IT language, so that they be able to explain how flows should be designed. We need people who understand both law and IT, because if we do not have this understanding, it will be difficult to design correctly the IT system. If we speak about digitalizing some business processes, it's one thing. If we speak about justice, then this is a totally different story. We cannot make process engineering using, but we have codes, we have the law that have to be taken into account. We have the Constitution, the Convention, the declarations. So a totally different approach is needed. And this approach is not learned in universities. It comes with experience. So it's very important that this new agency is able to recruit such people, and those people stay there and work there, because this will impact the speed of digitalizing the judiciary. Because yes, when we have a working group, we say that we need this and that. It would be great to have a module based on AI. But after this, the most difficult step comes. What actually do you need? Who should design it? How should design it? How it should be tested? How it should be rolled out? So it depends on us, and it depends on how much we are ready to invest in these processes. But that's possible, for sure. We have seen the realities that our colleagues are presenting. So if we are to analyze the experience of European states, they had such projects. Some of them were successful, others were less successful. But this will gives us the necessary enthusiasm, because if they manage to do it, that's for sure possible. If we start to do it now, then of course the result will be visible sooner than later. Now we do not fully use the potential of the information system. We already have some missed opportunities. And when we think about this, I say that first we have to make sure that all of the courts are okay, that use the existing systems, and then we can make the next steps together with their active participation. So I am optimistic regarding this, and for sure we will have soon the justice of the future. It depends on the tasks, how they are established, how the goal is defined, and the timeline, how it is prepared. The digital strategy sets a deadline at 2030. The Justice Digital Transformation Program sets the deadline of 2020. So this program is designed for 2025 to 2028. But if we are to see the current strategy, which includes a number of actions such as video conferencing, expansion of the e-file module, all of these measures were implemented, but not fully, because the idea was to expand the e-file for all categories of users. So we still have 1 more year to make this possible, but I do not believe this is realistic, so for sure the deadline would be postponed. But I want to tell you that for sure, if the needed budget is allocated and if the new agency is established, I believe that we can manage to do it in short period of time. But as I've said, it depends on how we set our tasks, how we define them, whether the timetable would be realistic, and so on. In my opinion, we need to have a group of key persons to implement this digitalization. Based on my own experience, I can tell you that there is a fragmented understanding. When we judges or lawyers tell to IT guys what are our needs. So I believe that we need to have an ongoing monitoring of this communication. Regarding artificial intelligence, again, on the basis of my own experience, I can tell you that yes, it's true. As Miriam said, if you add more requirements for the same category of cases, the results will be different for a certain number of trials. So how would we imagine that artificial intelligence works? It will never generate a court document unless we train it how to work. We are at a stage when we, first of all, have to learn how to work with this artificial intelligence. But to do so, we have to understand how artificial intelligence works. And only when we have this understanding, we'll be able to achieve results in real time. Regarding fighting corruption, the fight against corruption. So you can imagine a lawyer submitting a summons having all of the requests fulfilled. A certain judge rejects it without any grounds. Well, if a monitoring algorithm is implemented, the one who is monitoring these risks, these situations, will get this information. Look, there is a lack of clarity on that case. Then you will check that specific case and already formulate a certain conclusion or make a certain check. So for sure, AI can be used to fight corruption. Thank you very much. I think that we had a long day today, and a very productive one. When I came here, I had no clue about selective justice, but for sure you know a lot about it. But still, you have managed to enrich your knowledge.
I want also to thank the panelists from the international panelists who gave us today their insights and their experience in this domain. Thank you very much, Mr. Brooks, Mr. Schmidt, and Madam Stankovic. Thank you very much. Așadar, vă mulțumesc și dumneavoastră pentru.
Thank you as well for staying with us. We had a long day today. Tomorrow we'll have another long day, so we are waiting for you to come here with fresh forces to talk about the future of justice sector in the Republic of Moldova. Thank you. Have a great evening.